Hello, and welcome to the newest edition of Nelson Mullins' Education Law webinar series. We're glad you could join us today. My name is Dan Cohen, and I'm a partner on Nelson Mullins' Education Law team. Nelson Mullins is an AmLaw 100 law firm with about 800 attorneys and policy advisors across 25 offices in 11 states plus Washington, D.C. Among other practices, we have a dedicated team of attorneys focused on serving all legal needs of education institutions, including in the areas of labor and employment, healthcare, and issues affecting academic medical programs, construction and real estate, intellectual property, privacy and information security, and unique issues affecting education institutions like student and faculty discipline, sexual misconduct, and athletics. Each month, we host a free webinar addressing legal topics across these areas and sometimes more frequently as issues arise. Please feel free to contact one of our education team lawyers if you have any questions about our webinars or any other legal issue affecting education institutions. Today, Brandon Moulard is going to focus on First Amendment rights in the virtual schoolhouse, challenges for higher education and K-12 schools in the rush to go online. This abrupt shift to online education for brick and mortar education institutions has raised a host of questions, both practical and legal, when it comes to First Amendment issues. Today, Brandon will outline the law on First Amendment protections for students, faculty, and staff, discuss emerging issues related to academic freedom, free speech, and expression in the virtual educational environment, and provide practical guidance as possible in regulating and, if necessary, disciplining online speech instructional content and other issues that are speeding up in our move to go online. Brandon Moulard is a litigation partner in Atlanta's Nelson Mullins office. He has represented numerous public and private educational organizations, including K-12 public school districts, charter schools, private schools, colleges, and universities. And he's done so across a broad range of federal and state litigation, including civil rights lawsuits, Title IX, employment claims, personal injury suits, and special education disputes. He also conducts investigations for colleges and schools related to potential claims. And with that, let me turn it over to Brandon.
Thank you, Dan, and good afternoon, everyone. I appreciate you taking the time to join me today for this presentation. Now, back when my colleagues and I were sketching out this webinar a couple months ago, we had originally planned to present a top 5 or top 10 list of free speech and academic freedom issues, things like kneeling during the national anthem or the debate over political speech on college campuses. But then the coronavirus hit, and one by one, we watched as not only our clients, but school districts and universities across the country closed their physical campuses and were forced to offer instruction in a completely online model. This shift to an online learning model brought with it a host of novel challenges. We quickly began to see trolls infiltrating Zoom meetings and revealing other security vulnerabilities. It highlighted the impersonal nature of the digital classroom and the difficulty of spurring engaging discussion when the professor or the teacher controls the mute switch. It's created a host of technical challenges. And it also left students bereft of physical spaces to come together in person or safe spaces to march and protest and let their ideas be known. And teachers and professors were handed a digital course template and told to adapt at a moment's notice. And while the internet think pieces and webinars on distance learning came fast and furious, very few people, if anyone, is talking about how this new reality implicates the First Amendment's guarantees of free speech and expression. And even though the courts have had decades to develop the bedrock First Amendment principles governing student speech and academic freedom, that existing framework has never been tested in a world where the physical classroom no longer exists. It's unclear whether it fits at all. So today, I want to go through what that existing framework is and hopefully give some practical guidance on how it might graft onto our current conditions where all learning instruction is being done virtually and so much of student speech occurs off campus and online. So I have quite a bit to get through in this hour, and hopefully I can get through it all. I might have to skip a couple slides, but I'll try to cover everything. But I invite everyone to submit questions both through the question box on the webinar client, and also I'll share my email at the end of my presentation. So let's get into what the Constitution actually says. So here's the actual constitutional text. And the First Amendment is arguably the most famous of the constitutional amendments, but it's probably its most misunderstood. And that's doubly true when it comes to free speech rights of students and faculty members. So what the Constitution says is that Congress shall make no law abridging the freedom of speech. Pretty bare bones. So in the constitutional protections afforded by the First Amendment of the Constitution, they come into play when two things are present. One, you would need to have governmental action. And that means that action taken by purely private actors, such as private schools, do not implicate First Amendment protections. However, bear in mind that your state's laws may create free speech protections for students at private institutions. And many states have laws establishing that student handbooks or school policies and similar documents create a contract between a student and a private academic institution. So be mindful of those sources of protection outside of the First Amendment. Second, the government action must regulate or restrict the content or the mode or the form of the expression in order to implicate the First Amendment. So two things: government action by a public entity plus a restriction on speech and expression. That's the basic framework. But how does that basic framework relate to speech by students that occurs on school campus? To understand its implications for student speech in the classroom and campus, you have to be familiar with the four big cases in the Supreme Court's First Amendment jurisprudence: the Tinker case, the Frazier case, the Hazelwood case, and the Morse case. And we'll begin with the first case, Tinker v. Des Moines Independent Community School System. So here's a picture of Mary Beth Tinker when she was 13 years old in December 1965. And then she and her brother and a couple of friends decided to wear black armbands to school to protest the war in Vietnam. Now, the school board found out about this and they passed a preemptive ban on wearing the armband to school. But Mary Beth decided she was going to ignore that ban. And when she arrived at school on December 16, 1965, arrived at school on December 16, 1965, wearing the armband, she was asked to remove the armband and was then suspended when she refused. And the students were told that they could not return to school until they agreed to remove their armbands. And Mary Beth refused and she sued. And after a 4-year-long legal battle, the Supreme Court ultimately held for Tinker, and in doing so established that public schools do not have the unrestricted right to control and prohibit student speech. This became the case concerning First Amendment rights of students. Justice Abe Fortas, who wrote for a 7-2 majority of the Supreme Court, concluded that students and teachers do not, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. And for that reason, students may freely express their views and opinions, even if those opinions are unpopular or controversial. And schools may not engage in so-called viewpoint discrimination. That is, a school cannot favor or disfavor one opinion over another on a particular controversy, over a differing opinion. Now, with that said, Tinker made clear that students, while they have broad First Amendment rights in school, those rights are not limitless. A school may regulate or punish speech that causes a substantial and material disruption to the school environment. In addition, schools need not wait until that disruption occurs, as long as they have a reasonable expectation based on actual evidence that a disruption is going to occur in the future. But again, that disruption must actually be material and substantial. Later cases would establish that a slight disruption, which includes discussion, comments, or even hostile disagreement from other students, is typically not going to be enough. Now, after Tinker, the Supreme Court would elaborate on the First Amendment rights of students in 3 later cases: Bethel v. Frazier, Hazelwood v. Kohlmeyer, and Morris v. Frederick. And you can understand these cases as favorable to school administration in that they expanded upon the rights of school authorities to regulate student speech, even when that student speech does not cause a material or substantial disruption. Now, first of all, we had Frazier, where the court considered the rights of a student to give a speech at a school that contained an elaborate and drawn-out sexual metaphor. And the court sided with the school in that case and found that the First Amendment does not protect lewd, profane, or sexually explicit speech. And in Hazelwood, the court considered whether a school could censor content created by students for a school newspaper. And there the court found that schools have broad authority to regulate school-sponsored speech, such as a story at a school newspaper, as long as they have a pedagogically related reason for doing so. And we'll find later that that's an extremely permissive standard. And much later in 2007, in the Morris v. Frederick case, the Supreme Court established that schools may punish students or regulate speech that promotes illegal drug use. And in that case, you had a student who brought a banner to school that said "Bong hits for Jesus" and held it up during a school activity that occurred right outside campus. So, and also, while none of these cases explicitly state this, courts have widely and unanimously recognized that there is no First Amendment right to engage in speech or expression that reasonably could be perceived as a threat of school violence. So that's not going to be protected speech. So to sum up, the Supreme Court has said that student speech is protected by the First Amendment unless it falls into one of four categories. One, it causes substantial material disruption. Two, it is lewd, profane, or sexually explicit. Three, it is school-sponsored speech and there's a pedagogical reason for regulating it. Or four, if the speech promotes illegal drug use. But you'll notice that all of these cases concern on-campus speech and expression. None of them address how to deal with purely on speech. In fact, Tinker, Fraser, and Kohlmeyer, they all predate the internet. And nevertheless, the Supreme Court has never taken up a case to issue new standards applicable to online speech. And until that happens, Tinker, Fraser, Morse, and Hazelwood provide the basic First Amendment framework. And while that framework is well established, it contains a substantial subjective component to it. And as a result, courts have not been consistent in their application of these standards. And I'll return to that in a moment. Now, another thing you'll note is that the four big cases on student speech all concern speech and expression in the context of a K-12 public school district. But what about speech on college campuses? There the picture gets a little bit murkier. Now, the Supreme Court has repeatedly cited the Tinker case in its university student speech cases, but it's somewhat unclear the extent to which Tinker applies. And it's even less clear how viable the other three cases, Fraser, Hazelwood, and Morse, how viable those are in the college environment. And to this day, there's still sharp debate among the courts to which Tinker and the other cases apply in the university setting. And there's good reason to treat colleges and K-12 schools differently. Students in college tend to be older and more mature. Colleges are supposed to be a marketplace of ideas where students encounter and share differing viewpoints. A lot of times college students live on campus and they're constantly subjected to college rules and regulations. So with all that said, what is the standard applicable to speech that occurs on a college campus? In 1972, the Supreme Court recognized in Healy v. James that college campuses, like public K-12 schools, are entitled to First Amendment protections, excuse me. And a year later, and the court there stated that states and colleges and universities are not enclaves immune from the sweep of the First Amendment. A year later, in the Papish case, the Supreme Court considered whether a university could expel a journalism student for distributing a newspaper on campus that contained profanity and an inflammatory political cartoon. Excuse me, I'm getting some comments about some of the audio here. Let me just double check that my tech is working all right. Okay. So in the Papish case, the court recognized that the court found that the school had improperly punished the student based solely on the content of its speech. And it found there that, quote, the mere dissemination of ideas, no matter how offensive to good taste they may not be shut off in the name of the conventions of decency alone. So there you can already see a divide between the Supreme Court's rules regarding speech on a college campus versus speech on a K-12 campus. So you see a distinction between the Papish case, for instance, and the Fraser case. And in the Widmar case in 1981, the Supreme Court again recognized that students enjoy broad free speech rights on campus, and that colleges may only regulate student speech based on reasonable restrictions on the time, place, and manner, or if a student's speech infringes on the rights of others to obtain an education. So that's the basic rule. Similar to Tinker, a college, just like a K through 12 school system, can prohibit speech or can regulate speech that interferes with the rights of others or interrupts class. Alternatively, colleges may implement reasonable regulations on when, where, and how speech may take place. And if a student's speech violates those reasonable regulations, it can be punished. So that's the general framework. Let's consider how those basic principles might play out in the real world. So this gentleman with the good hair and the cool shirt has gained some notoriety earlier this month. I won't use his real name, but you can look it up if you're curious. I'll just call him Joe for short. Now, Joe is a student at an elite law school where he serves as the president of the right-leaning organization, the Federalist Society. And Joe had his 15 minutes of fame earlier this month when, during a Zoom lecture on criminal law, he brandished a handgun and proceeded to examine, clean, cock, and uncock the gun for about 15 minutes, all in full view of 40 of his classmates, his professor, and for good measure, a judge who the professor had invited as guest speaker. Now, when interviewed by a media outlet about the incident, Joe claims that he had no ill will, that his brandishing of the gun was innocent. He said he was preparing to shoot "quote unquote" vermin on his grandmother's property, and that he didn't mean to cause any disruption in class. Now, the law school that Joe attends prohibits firearms on campus, but this didn't occur on campus. Joe was at home. He just happened to be on camera while the campus was closed due to the pandemic. And Joe's school policy and its technology use agreement does not specifically address this type of situation. This is a real-world example of the type of speech and expression that can occur in a distance learning model. And if a school wants to regulate this kind of expression, what are its options? Now, how do you even begin to analyze a case like this? So I've laid out some initial considerations. To begin with, the age of the student is important. Joe appears to be in his 20s, maybe his early 30s, but if he were a young child who pulled out a handgun in the middle of his language arts virtual learning course, for instance, the elementary school would probably have good reason to think that he posed a danger to himself or others. He's too young to be in possession of a gun, and they'd have good reason to act. We also have to consider what type of institution Joe's at. Is he at a private school or is he at a public institution? If he's a private school student, that school might have greater leeway to act in response to his speech if it chooses to do so. But private schools should also re-examine their speech and expression policies and technology use agreements and and determine whether or not they encompass student conduct and expression in the distance learning setting. Do your policies and technology use agreements even deal with a situation like this? And also, where and when did the speech take place? Here, it's at Joe's home. So aside from those initial considerations, we have to work within the existing First Amendment framework. And that means we need to go back to our big Supreme Court cases. Now, and examine, first of all, what is the nature of the speech? Now, this scenario doesn't involve lewd or sexually explicit speech. It doesn't concern a school newspaper or any other speech that could be considered school-sponsored. And Joe wasn't talking about using illegal drugs. He was at his house and he engaged in silent expression in his virtual class. So we probably have to analyze this case by asking whether his conduct caused a disruption of the school environment or interfered with the rights of others. Before we can even get there, we have to know, what does disruption look like? What is expression that is disruptive enough that a school can act? So I'm going to begin by talking about what's typically not enough. So if your school staff investigates or issues some sort of disciplinary response to a student's speech and expression, that's typically not going to be enough. And you can understand why. it would be circular to say that the conduct that justifies the disciplinary response is the disciplinary response itself. So courts are going to reject that reasoning, and we see that in the Gonzalez case. In the Gonzalez case cited here, where some students engaged in a sit-in to protest alleged favoritism and bullying by a teacher, and the school tried to claim that the fact that staff had to take the time to look into the matter and respond to the students' conduct was sufficient disruption to make the speech not protected, and the court rejected that argument. In addition, mere curiosity or chatter or even vocal disagreement from other students in response to another student's speech or expression is probably not going to be enough. Here we have the Holloman case, which has become a benchmark case at the 11th Circuit, and there the student refused to stand and recite the Pledge of Allegiance and instead silently raised his fist in the air. And when the court tried to discipline him for it, he sued, and the Court of Appeals ultimately found that he was within his First Amendment rights to do that, even though his conduct had elicited some minor response from his classmates. Not surprisingly, a school's disagreement, even vehement disagreement with the content of a student's speech, is not going to be enough to justify regulation. In the VA case, a student kneeled during the Pledge of Allegiance at a football game, and this made his football coach very, very upset to the point where he disciplined the student. The student sued and ultimately won, the court finding that his speech was protected expression that did not cause any material substantial disruption, and that the football coach's disagreement with his conduct was not enough. Generalized insubordination is also not going to be enough. So the KB case here, which is a case that I actually worked on, this involved a student who had made about 3 dozen stickers that said fire and then the name of the principal, and that had a picture of the principal's face that student had downloaded from LinkedIn. He put one on his phone case and his book bag, and then handed the rest of them out to his buddies, who then proceeded to stick them on water fountains and school walls and desks and lockers. And the school had to take time to peel those off and then corral the rest of the stickers that were floating around the school population. And the court found that even though calling for the termination of the school's principal was demeaning and embarrassing and probably insubordinate, it didn't cause an actual and material disruption to the learning environment. So simply being insubordinate is not enough. And unless the speech is lewd or profane or concerns the use of illegal drugs, courts are really hesitant to find that speech is inherently disruptive. And the KB case is a good lesson on that principle. And then finally, a school's fear of taking a position on a controversial topic is typically not going to be enough to justify regulation of speech on that topic. So in the MC case, the school had passed a rule basically trying to tamp down on speech concerning school shootings and also the Second Amendment. And the school said they did so because they were afraid of being perceived as taking a side on that debate. And the court said that regulation went too far and was without material evidence of an actual disruption of the school environment. The school's fear of being perceived as partisan or biased was not enough to justify a broad prohibition of speech. So be mindful of these types of justifications. We see these a lot in cases, and the courts are fairly, these are all recent cases, but the courts have been fairly consistent in rejecting defenses to First Amendment claims based on these types of justifications. So what is enough? Now, typically courts require a tangible disruption or a reasonable forecast of disruption before the school can act. That means that the teacher's lecture or the professor's lecture actually has to be interrupted. Alternatively, if a school has good reason to believe, has a reasonable basis to forecast a disruption, it doesn't have to wait until that disruption actually occurs. So one example of that is when a school gets wind that students are going to mount a protest or demonstration that's going to block a student's access to part of the campus and prevent them from going to class. That's the sort of thing that the school is probably going to be able to prohibit or regulate in another way. If speech is part of a school-sponsored activity, then schools typically have much greater leeway in regulating it. So for instance, in this Alabama case I've cited here, the school had pretty rigid restrictions on the manner in which students could campaign as part of the student government elections. So they put time restrictions and space restrictions on when the students could distribute flyers, when they could post signs, when they could put up posters. And when some students challenged that on First Amendment grounds, the court basically said that the student election is school-sponsored speech. And because the school had articulated some pedagogically related reason for implementing those restrictions, that was going to be enough to uphold that regulation. So the takeaway there is that if you're dealing with school-sponsored speech, courts give broad discretion and authority to schools to put regulations on speech in that context. I mentioned this a minute ago, but there's a lot of cases that fall into this vein, so it's worth repeating. Threatening and harassing speech can be punished or otherwise regulated. And courts have given schools broad authority to regulate this kind of speech. For instance, in the McNeil case, this was a high school student, I believe. He wrote a hit list of students that he wanted to harm or kill in his private journal. Now, the student didn't share the journal with anybody. Instead, one of his parents found it and then shared it with a therapist, who in turn contacted the police, and then the police contacted the school district to notify them about what the student had written. Acting on that alone, the school district expelled this student. And the court found that even though the student had not disseminated that speech or communicated it to anybody, the fact that it was threatening justified the school to preemptively act and punish the student for it. And this is also a situation that's not unique. A situation that's not unique to K-12 school systems. We see that in the Koppel case cited here. You had a university student who kept sending harassing, sexually explicit text to another student. And the court found that that was the kind of harassing, threatening speech that was undeserving of First Amendment protection, and the speech in the school was justified in disciplining the student. So, getting back to our friend Joe, is the speech constitutionally protected? I think it is. Remember, we basically have no case law specific to student speech during virtual instruction. So we have to use the existing First Amendment framework established by the Supreme Court dating back to the 60s. And under that framework, we have to look at whether or not Joe's speech caused an actual disruption. And there just seems to be no evidence that he actually disrupted his class. He didn't threaten anybody. Some students might have looked at him and raised an eyebrow, but the lecture continued unabated. And there's just no proof that he caused a tangible disruption to the class or he interfered with the ability of others in his lecture to learn. So in the absence of that sort of evidence, courts are likely to hold that his brandishing of the handgun during his Zoom lecture is constitutionally protected activity. But consider whether or not the outcome would be different if Joe had, for instance, pointed the gun at the camera and pulled the trigger. Maybe that's more akin to threatening speech, which courts are more willing to allow schools to regulate. Or what if Joe had pointed the gun at himself? Again, courts may be more willing to allow schools to regulate speech that if they have a reasonable belief that a student poses a harm to himself. Let's consider another hypothetical. So these two individuals are high school seniors at a school in Georgia, just west of Atlanta. And just last week, they posted a highly offensive video to the social media platform TikTok, where in a video they recorded at home, they made a series of racist and derogatory statements about African Americans, including using the N-word and invoking several well-tread racial stereotypes. Now, I don't dare show the clip. It's really terrible. And in fact, the clip is so vile and inflammatory that it went viral within hours. And as a result, these students' high school was trending on Twitter by Friday morning. And by Friday afternoon, the district had expelled both of them for their social media post. This situation illustrates a scenario that the existing First Amendment framework is poorly suited to deal with. What is a school supposed to do when its students engage in highly inappropriate, inflammatory speech on social media off campus? The rules announced by the Supreme Court were all created based on the assumption that student speech would occur on a physical campus or in the context of a school-sponsored activity. But those cases did not consider, they couldn't really dream of our current reality, where students are heavily engaged in speech and expression online, in particular on social media platforms. That speech technically occurs off campus, especially now where campuses are closed, but it can reach classmates and thousands, if not millions of others instantaneously. So how do we deal with this new paradigm without new rules outside of the existing First Amendment framework? Well, the short answer is that there is little consistent guidance on the extent to which school districts and colleges may regulate off-campus speech. It is a minefield. And the Supreme Court has repeatedly refused to take up a case that deals with this issue. As a result, we're left with the creaky old First Amendment framework to sort out these modern questions. I will say though that as a general matter, it's often more difficult to punish or regulate this type of speech and expression. And the reason for that should be fairly obvious. It's difficult to draw a connection between any sort of impact on campus and any sort of interference with instruction with speech that occurs on a social media platform outside of school hours off the physical campus. But that doesn't mean that it's impossible to regulate or punish this type of speech. It's just that the courts are not consistent. So I'd say tread carefully and consult with your counsel before your school reacts too swiftly to a student's comments on social media. And to illustrate how fraught this area of the law is, just consider the BL and the Johnson cases I have cited here in the third and fourth bullet points. These are two separate cases from two separate courts issued less than a year apart, and they share virtually identical facts. Both students, in both cases, the students were dismissed from their respective cheerleading teams after posting some bad language to Snapchat. And yet, the two courts came to diametrically different conclusions. In BL, the court said that the school violated students' constitutional rights by disciplining her for her speech on social media. But the Johnson court said that the school district was within its rights to discipline the student. How you square those two cases is really beyond me. They seem to be incompatible. And throw on top of that a case like AS, where a student posted a doctored image of a classmate in a casket as if the student were dead. The school disciplined the student for that post, and the court found that the school was within its rights to do so. On the other hand, if you go to the JS case, a 2011 decision, the school district, the court found that a school district did violate the First Amendment when it suspended a student for creating a MySpace profile, for those of you that remember MySpace, that mocked the school principal and contained a variety of profanity and other sexually explicit content. And this isn't a problem that is unique to K-12 school systems. We see that in both the Keith and the Hunt cases cited here. And in both those cases, although they came to similar results, finding that the university was within its rights in regulating the speech and punishing the student for social media posts, both courts recognized that the right of a student to engage in off-campus speech, off-campus online speech on social media is not clearly established. So again, the lesson here is that disciplining students for off-campus speech is possible, but it's going to be a case-by-case analysis, and the law varies dramatically in different parts of the country. It might even vary judge to judge. So if you want to go this route, and if at all possible, try to consult with counsel, because lawsuits over these types of claims can be difficult and costly and drawn out. Plaintiffs that win them can get monetary damages, and they can typically also get their attorney's fees back. So they can be bad news. All right, so let's got about 25 minutes left. I want to switch gears with my remaining time and talk about employee speech and expression under the First Amendment. And as we did with student speech, I'll begin with the basics. Now, the law governing employees' First Amendment rights grows out of a tension between two competing concepts. Now, on one hand, teachers and professors and other public employees are citizens too, and they have opinions about matters of public concern. And they shouldn't have to forfeit their First Amendment rights to express themselves just because they go into public employment. That would be fair. On the other hand, government employers, including school districts and public colleges and universities, they should have some measure of control over what their employees say. So how do you balance these two competing interests? Well, that's what the Supreme Court tried to do in the Pickering v. Board of Education case in 1968. And there, the Supreme Court said that a teacher's speech might be protected when she is speaking as a citizen, as opposed to speaking as an employee, if the speech relates to a matter of public concern. So when those two elements are met, the teacher is speaking as a citizen on a matter of public concern, you have to balance the employee's interest in speaking versus the school's interest in regulating that speech. Now, to complicate things even further, in Garcetti, the Garcetti v. Swallows case in 2006, the Supreme Court recognized that simply because an employee's duties involve speaking on matters of public concern, for instance, in the case of a district attorney, that does not mean that employee speech is protected. And before both of those cases, the Supreme Court in the Sweezy v. State of New Hampshire case in 1957 recognized that what we now refer to as academic freedom, which concerns the right of faculty members to choose how they develop their curriculum and how they teach that curriculum, is an important First Amendment value. So how do these principles work together? All right, so for you visual learners, I've tried to create a chart that breaks this all down. So you always analyze these types of questions, the question of whether or not an employee's speech is protected, by first asking, when the employee spoke, was he or she doing so as an employee or as a citizen? If the employee is speaking pursuant to his or her official job duties or about matters that are only germane to his or her duties and responsibilities, then that employee's speech is not going to be protected by the First Amendment. In other words, the employee is speaking as an employee, and employers are allowed to regulate how their employees speak in that context. On the other hand, if the employee is speaking as a citizen, and that speech is about a matter of public concern, then that employee's speech might be protected. And in that situation, the courts are going to balance the interest of the employee in voicing those opinions versus the interest of the employer in regulating them. Now, of course, if an employee is speaking as a citizen, but it's just they're speaking on a matter that's not a matter of public concern, some sort of personal grievance, for instance, and that speech is not going to be protected by the First Amendment, and the employer is free to regulate it without repercussion. To back up just a bit, and if an employee's duties require him or her to speak on matters of public concern, that employee speech is not going to be protected. That's essentially the rule announced in Garcetti. And this is always going to be a case-specific analysis. Beyond this general framework, it's difficult to distill any lessons that are generally applicable to all public employees. But what about instructors and professors? How do these rules apply to academic personnel? Well, the courts really aren't unanimous on this question, and many courts haven't even come up with a cogent way of balancing the concept of academic freedom as a First Amendment value with the decades of decisions by the Supreme Court on employee free speech. But in my view, the courts that have approached this the best way use the method of analysis depicted on the slide. And you'll see courts, for instance, in the Fourth and the Ninth Circuit, and I believe in the Second Circuit as well, use a method of analysis that's similar to this. And under this method, what you do is you initially try to figure out what is the nature of the employee's speech. Is it academic in nature or is it administrative in nature? If it's administrative in nature, then the Garcetti rule is going to apply and the employee speech is less likely to be protected because it's probably going to be pursuant or about official job duties, and it's probably not going to be about a matter of public concern. On the other hand, if the speech is academic, meaning that it bears some connection to to instruction or some other pedagogical objective, then that's probably going to fall into the Pickering box. And in that situation, the courts are going to balance the interests at play. If the speech, for instance, what are the reasons that the institution has for restricting or punishing the speech, and do those interests outweigh the professor's interests in academic freedom? Note that in order for speech to be protected under this analysis, at a minimum, it has to be germane to some sort of pedagogical objective. In other words, it has to be germane to a course of scholarship or some sort of instructional content. For instance, if a professor just uses a bunch of profanity in class or explicit language or is harassing his or her students, and that's disconnected from any sort of lesson or pedagogical aim, that speech is probably not going to be protected because the universities or the school's interests in regulating it are probably going to be weightier than the professor's interest in using that type of speech. But if the speech, even if it's incendiary, is germane to some pedagogical interest, then courts are typically reluctant to allow universities to regulate it. And the courts will often find that the interest in allowing the professor's academic speech outweighs the institution's interest in regulating it. Now, this general framework should apply even in the distance learning model. Now, we don't have any case law on that, but it seems that it's a much tighter fit to the distance learning reality we find ourselves in now than perhaps the existing framework of student speech. So how does this work in practice? I have a hypothetical here. Unlike the previous two, I'm not aware that this actually happened. So this is not something that I pulled from the real world. So a tenured professor teaches a class on social movements. And one of the big projects on his syllabus for the end of the year is for students to actually organize a protest around a topic that they find interesting. Now, in the meantime, the pandemic hit and the teacher was forced to go online. And at that point, the teacher amended his syllabus to state that the protest would have to be organized virtually. And during class discussion on the project, students voiced increasing frustration with the university's tuition refund policies after the pandemic. And the professor encouraged the students to move forward with that frustration. The students then, in turn, banded together and organized a virtual protest against the university on Twitter. And their Twitter campaign gained a massive attention in the media and on various social media platforms. And as a result, the university began to see its enrollment drop and the demands for refunds from students begin to roll in. Now, as you might imagine, the university is pretty unhappy about this, and they want to do something about it, including disciplining the professor and regulating these types of assignments in the future. But can they do so? Now, this is going to vary from circuit to circuit, but it's my opinion that the professor's assignment is likely protected by the First Amendment under the concept of academic freedom. Now, let's go through the analysis of how I came to that conclusion. So first of all, we are dealing with speech that is academic in nature. So it's not purely administrative, so we won't be dealing with the Garcetti rule. And because it's academic in nature, we're going to be under the Pickering test. And under that Pickering test, we need to balance the interest of the professor in creating this assignment against the interests of the university in regulating it. And there's really no question that the speech here, the giving the assignment, it bears some connection to a pedagogical topic. I mean, the professor was teaching social movements, and he's revamped his assignment to be done safely in light of the ongoing health and safety emergency. And as designed, the assignment doesn't implicate any types of unprotected speech categories like lewd or vulgar speech or speech that concerns illegal drug use. In other words, the types of speech that the university would want to protect its students from. And even though the class discussion resulted in a controversial topic that affected this hypothetical university, that doesn't change the fact that this is academic speech designed to engage students in the subject of the course. So when we go into the balancing of the interests, it asks whether the institution's interest in protecting its business outweigh the professor's interest in teaching its course. Most courts will probably find in favor of the professor on this one and find that it's protected. The assignment itself didn't present issues to the university. It's how the students respond to it. And the professor isn't just using the assignment to express his own political views, which might weigh in the university's favor. In light of this, if the fictional university punished this professor for what happened, they likely have a nasty lawsuit on their hands. Now, they may be able to argue that the assignment was problematic as structured, and some courts have been sympathetic to that kind of argument when tamping down on academic freedom. But that's likely going to depend on the circuit that your case occurs in, and that kind of outcome probably represents a minority opinion among the courts. In all likelihood, if the university punished the professor for signing an assignment that had these sort of destructive but unintended consequences, the professor would probably be able to assert that his First Amendment rights to academic freedom come into play, and if the school wants to regulate the assignment, the professor would have a decent argument that its First Amendment rights have been violated. Now, that's all assuming that this is a public university. For private universities, of course, First Amendment rights are not going to come into play, but you need to look at your academic freedom policies, your employee handbooks, and the like to analyze this type of hypothetical. And that might also include, not only handbooks, but university policies and the professor's contract. And also consider a slight change in the facts. What if the professor gave the students the idea to protest refund policies? In that situation, that might be a little bit more antagonistic towards the university. But it's arguably still protected as discourse, as academic discourse, even though it's controversial in nature. And it's certainly relevant to the course's subject matter. So what if we change the facts just a little bit more? What if the university knew about the Twitter protest and then tried to restrain it ahead of time? Can they do that? Probably not. As much as the university would want to avoid the negative publicity that comes with the Twitter campaign, the university would not be able to get away with this kind of prior restraint on student speech. And the university setting where students are provided generally more freedom than K-12 students, and where the speech is not occurring via school-sponsored vehicle for expression, the university would not be able to exercise prior restraint on the speech, no matter how troublesome it ultimately is for the university. Now, again, a private university may be able to get away with some kind of restrictions on student speech that would prevent this from happening, since they don't have to observe First Amendment rights for students. But most private universities have internal policies or contracts, other types of conduct rules that would allow and observe student speech rights in some capacity. So bear those in mind. So let's change the facts one more time. What if the professor encouraged the students to physically meet on campus to protest the school's closure? Could the university intervene then? I think the answer is yes. This is when the balancing test probably tips in favor of the university. When you change the facts to a physical in-person protest set to occur on a closed campus that's been closed for public health and safety reasons, and the protest would likely contravene state shelter-in-place rules, the university would likely be justified in intervening more so than it would if it tried to clamp down on the Twitter protest. So I have a few parting tips and reminders as we wrap up. I only have a few minutes left. These are strictly First Amendment concerns, but I think they bear mentioning. As you move to a distance learning model, of course, beware of security concerns. There's been a huge rash of hackers and Zoom bombers that have been showing up in lectures and disrupting the lectures or recording the speech and then blasting people on social media for it. So make sure to the extent possible, make sure your teaching staff is only using software that your institution has an official relationship with. Try to train your teachers and professors on how to change the default settings on your distance learning software to increase security. And if possible, only use password protected meetings as opposed to public invitations. And consider appointing student monitors who can watch for trolling and folks like Joe who like to brandish their guns in the middle of lectures. Beyond that, review your institution's speech policies and codes of conduct and technology use agreements with an eye toward distance learning. Does your policy cover conduct in a virtual instruction model? Or is it only geared towards conduct that occurs on a physical campus or on social media? Now, remember that you're not going to have time to consult with counsel. Your professors are probably not going to have time to consult with counsel before they boot a misbehaving student from their lectures or they hit the mute button. So do your best to make sure that your policies and codes of conduct address the situation ahead of time, and if possible, provide training to your professors and to your teachers. And for K-12 schools in particular, it's a good idea to consider your disciplinary options. When students are not actually going to school, your progressive discipline policies may not make sense anymore, and they may not be viable. So ask whether the old consequences make sense in the new paradigm, and modify them and consult with your school leadership to make sure that you're coming up with appropriate disciplinary responses. All right, we are just about at 1:30. I appreciate everybody's time. I hope this was somewhat useful and informative. I invite you guys to post questions in the question box. I won't get to those right now, but I promise I'll get to them afterwards. I'll get a report that shows whatever you've posted, and I'll reach out to you individually with my response. And if you haven't posted any questions in the chat box, please feel free to email me at brandon.moulard@nelsonmullins.com, and I promise I will get back to you. So again, thank you all for your time, and I hope you all stay safe and healthy. Thank you very much. Bye-bye.